Well, good afternoon, everybody, and hello, David. Good to see you.
Likewise.
We appreciate everybody joining us to think about RIF and some other legal issues this afternoon. So, for those of you who've joined us before for our Q and A's, this one we've got a little bit more structure because we want to cover some issues specific as it relates to reduction in force. But then open it up to Q and A. So as we go along, don't be shy. The chat box is open. We're actively monitoring that. So if you've got a question about anything we are talking about or anything we say this afternoon, feel free to pop those questions right in the chat box, and we will do our best to see what we can come up with. But any thoughts, David, before we jump right in and start talking about issues of RIF?
No, I think we got a lot to cover today, so let's get going.
Well, let's do it. The reason why we felt it was important to put this topic together just to have a conversation about issues of RIF today is that we anticipate that RIF is something that districts are going to be talking about with a lot of the unknowns given the state budget and issues related to it, and trying to figure out where things reside, and also recognizing that over the past few years, maybe we haven't had as many RIFs. And so maybe many of us who are in the seats we are in don't have as much experience as maybe we would like to have to make sure that we understand all the issues available to it. So we want to make sure that everybody is, making sure that we understand those issues related to RIF and what those basic procedures are.
And one thing that I hear a lot is, hey, where are your guys' RIF forms? Right? Where's the RIF form? I've got all these people I need to RIF. I just need the form for it. And I think that's a misconception as to where the danger lies in a reduction in force. The first thing that concerns me when somebody says, I've got this guy I need to RIF, or I've got these people I need to RIF, is the first thing that pops in my head is, do you mean you have positions you need to RIF, or do you have people that you need to RIF? Because if we're talking people, this may not be a reduction in force. And so that's one thing that as we get moving today, I think we're going to want to sort of distinguish whether we're talking about a dismissal or a reduction in force truly. And then the second thing is the form. Brandon, I don't know about you. I haven't looked at one of yours in quite some time, but at least for me, I've never done a form ever. Every single RIF I do looks different. There's absolutely, without any question, we're reliant very heavily on some staffing help to sort of use some clauses I've used before in different RIFs. But I mean, every single year, there's a clause I add or take out or move. And every single time I do a RIF, there's some squirrely thing that I need to deal with in there. And I can't tell you how many times somebody's brought me a position and a person and said, this is who we're riffing. And I get halfway through it and I'm like, nope, wrong person. Right position, wrong person. And so we need to make changes. And that's really where all the risk is in a reduction in force, is making sure that you've got the right targets. So I hope today we'll be able to clear up a lot of those misconceptions for you.
Yeah, I think that's true. I think one of the things that is certainly we want to emphasize as we walk through today is that based on individual collective bargaining language, based on how your positions are structured, based upon combinations of positions, that could certainly impact things. And so there's not necessarily always a one size fits all answers to RIF. But, I think we want to start with sort of 5 big picture reminders that are important for us and that we want to keep in mind, so that sets the framework. I mean, we're going to walk through the mechanics really step by step. But I want to make sure that we start with understanding some of those big picture key reminders just when we're talking about reduction in force and RIF and the language of it. And number one here is just remembering what a RIF is, right? A reduction in force, is when we're reducing the number of employees or discontinuing a particular type of service, which results in a layoff or the reduction of the number of employees, or a reduction in hours of a school employee, then that's what we call a RIF. School code refers to that as an honorable dismissal. So when we're talking honorable dismissals, we are always talking a reduction in force. That is when we are laying someone off, reducing the number of people, eliminating positions, or reducing hours for employees. That's what we mean by RIF. And we don't want to confuse that with other means of dismissal that might be available to us under the school code.
And one place I think that people get confused is because of that language, honorable dismissal. We think a lot of times, well, I want to be nice about it. And so I'm not happy with this guy, but I'm going to honorably dismiss him and sort of take the temperature down. And while I think that's a good sort of bargaining instinct, unfortunately, it doesn't work for purposes of the code, because one of the things that you do when you honorably reduce somebody is give them a recall right. You also cite their pre-existing bumping rights. And I want to be clear that it is not the employee's right to bump. It is the employer's duty to protect the employee's right, so that it is the employer's duty to ascertain where the person bumps, to land them in a position which retains their employment, thus resulting in someone else ultimately being reduced. So I may lose an English teacher, but because that English teacher is a long-term tenured teacher who also is licensed in math, endorsed in math, it may be that I actually lose my math teacher. Well, but I like the math teacher. Tough. He's a first-year non-tenured teacher. The bumping is not, we don't offer it to the English teacher and say, if you'd like the math position, you may have it. We are going to RIF the math teacher and then transfer her to the math position.
Yeah, and so that's why it's so important to understand that we're using the right language to start with. And closely connected with that is recognizing that a RIF is not the same thing as a dismissal for cause, right? Even when we are deciding to not bring a non-tenured teacher back, which I think we've oftentimes, again, softened that language by calling it a non-renewal. I mean, that's not really a language that is anticipated by the school code in the same way. And so we need to make sure that we are not using those interchangeably. And I think historically, maybe it had less impact because prior to Para and SB 7, non-tenured teachers didn't have the same recall rights that tenured teachers did. And the process of RIF was such where the legal difference was less important than it is today. But it is important to recognize we really have two paths here. We're either riffing because we're eliminating a position, or we're dismissing someone because we don't want them back, and they're not interchangeable.
Yeah, and when we talk about dismissal, and by the way, I don't ever use the term non-renewal, because 24-12 and 24-11, 24-11 cuts off rights toward tenure, 24-12 establishes reduction in force in recall rights. I don't ever they both use the term non-renewal, and it's very confusing. And I'm sympathetic to administrators and boards who over many years have gotten used to the idea that there's a non-renewal and there's a reduction in force. And at this point, it's a misnomer, because it's the same word in both statutes. There is either a dismissal for cause or a reduction in force. A reduction in force protects bumping rights, protects seniority to some degree, which we'll talk about later, and protects, or maybe a great degree, depending on how you read the Elliott case, and protects a person's right to recall for as much as 2 years under the code. A dismissal is exactly what it sounds like. It's, for lack of a better word, it's firing someone. It's that you don't have the licensure required for this position, or the endorsement required for the position in which you're teaching, or you don't have you have not demonstrated good performance and you're a non-tenured teacher, and I need to cut off your contract. But I want you to remember that the duty is upon the school district to make sure we cut off the rights on time and in accordance with the statutes. It's not a matter of whether or not the employee calls those out or wants to exercise them, it's our duty to protect them first, or to be compliant with them first.
So, and this gets to a question that we asked. We are talking about all school employees here, but the statute and the provisions are different whether we're talking about teachers, professional educator license employees, what we used to call certified employees, or what the school code calls our educational support employees, our ESPs. And these rights exist regardless of whether they're in a union. And I think that's also an important point, that I think sometimes there's the misconception that employees that are not in a bargaining unit somehow are exempt from these rules, and that's not true at all. So we are going to walk through the nuts and bolts of both of these processes today, both the reduction in force for our teaching staff, our professional educator license staff, and those for non-certified staff.
Yeah, and remember that when we've got a collective bargaining agent, it's a good instinct. We want to start with the collective bargaining agent, but also remember that even with no bargaining agent, just as Brandon said, the statute still applies regardless. This is true both teachers and non-certified employees, and there are statutory obligations, including keeping a seniority list and having that seniority list available for publication, and requiring that seniority list be published by a certain period of time. So that, and that includes people who are on those seniority lists who are exempt from a bargaining unit, meaning I could have two district secretaries who would theoretically be exempt from, if they ever did certify, they'd be exempt, and they're still subject, they still go onto that seniority list somewhere. They may be in their own category because of the exemption of their position, but they're still going to be in seniority order, so that if I lay somebody off, it's going to be the least senior person within that category. We'll talk about categories more in a little bit.
And of course, the fourth reminder here is when we do have a union involved, there are some additional requirements here, because courts in Illinois have been very clear that the decision to RIF is a mandatory subject of bargaining. And that's more than just impact bargaining, it's decisional bargaining. And I think that's also an important distinction. I think there's oftentimes a misconception that we're only required to bargain over the impact of the RIF, but courts have held that the decision to RIF itself is a mandatory subject of bargaining.
And you know, one of the questions I get every year, particularly in large districts, and particularly when we have people move into the large district for the first time from maybe a smaller district or from a role in a building, one of the questions I get a lot is, the union filed a demand to bargain. What do we do? This is crazy. We're going to bargain over a RIF? And I can tell you that, having done it a whole bunch of times, it's never been very scary in any place I've ever been. Because usually, remember, the union has a duty of fair representation to not only the people who are RIFed, but also to every other person in the district that they represent. Ultimately, if you're going to lose this position, there's going to be more availability of funds for everybody else over time, and that may be necessary. I can tell you that, just having talked to my father, who litigated the Central City case, he said at the time they were scared to death that meant no more RIFs. That was the position all of them were taking at the time. They thought, there's no way, we're never going to be able to RIF again, because the union is going to prevent it. They're going to file these demands to bargain. They're going to hold us up on status quo. Remember, when the union files a demand to bargain, we do whatever it is we bargain, whatever we agreed last, until we reach agreement or impasse. But practically, that's not what's happened. Practically, the union understands that sometimes you do have to do a reduction in force. And at least it's been my experience, and Brandon, you can certainly, if you've had other experiences, I'd be glad to be educated, but at least in my experience, generally speaking, the union wants to know before the board takes action, before, not after, and that's critical. Before the board takes action of any sort at all, don't blindside the union. Union comes into the shop first, and they're going to be on the inside listening to what's happening. And then, generally speaking, even when they file a demand to bargain, which a lot of times doesn't happen until after the board takes action, the union then is looking for things to try to mollify everybody, to try to bring peace again. Maybe they want to extend the recall deadline. Maybe they want some extended insurance benefits, or maybe a little bonus on the way out. I've even had districts, I had one district where we bargained for 2 complete years, even a year after the people's rights had expired. And they didn't agree to anything at all. In fact, the union rep said to me at the end of the final meeting, which was days before the expiration of their rights, but how many people are still left in the recall pool? I said, they've been gone from the recall pool for a while. He said, well, our only proposal was 2 years. 2 years is up tomorrow, or 2 days from now. He said, guess that's it. That's how it ended. And by the way, they didn't stop the RIF from happening in the first place. And that generally has been my experience, is they're going to allow the RIF to go forward. But remember, there's an additional benefit to bargaining as well. And that is that you get insight as to what procedural hurdles the union sees are coming. And sometimes, not always, but sometimes they give you a heads up on that and help you out a little bit.
Hey, David, a question we got a few minutes ago. If we give notice to the union that we're going to conduct a RIF, is it up to them to initiate bargaining that decision?
Yes, it's so the procedure is under the Bargaining Act, the procedure, the Labor Act, the procedure for bargaining is the board declares what it's going to do to change working conditions, hours, terms, conditions of employment. The union then has the right to demand, and then you hold status quo during the time that you're bargaining, unless the union lets you go forward. In practice, the way that works is we've got to let the union know before we go to the reduction in force, to the board with a reduction in force. Then if they want to bargain, sometimes they're just coming in and talk to you. They don't even use the term bargaining. They just come in and talk to you about it. Sometimes they'll file a written demand, but you don't have any duty after you've asked them to bargain. Now, sometimes a district knowing that they're going to have some bargaining will also include a waiver in there. Hey, I waive my right, the union, waive my right to bargaining over this topic. But you don't have to do that. Once you let them know, as long as you can prove in writing you've done so, you've done your duty.
And then our fifth reminder here to start is all these RIF procedures are under a huge cloud of uncertainty because the Seventh Circuit found that Indiana's nearly identical statute was unconstitutional. In the Elliott decision in late 2017, they found that the RIF procedures in Indiana were unconstitutional and that they unconstitutionally interfered with the tenure rights of teachers who had acquired tenure prior to the change in the statute. Why the heck do we care what Indiana's statute happened? It's because it was identical to ours, passed around the same time that looks like Para and SB 7 that created those evaluation groupings and everything else. What happened in Elliott is you had a 30+ year veteran teacher who was RIFed ahead of a much less senior teacher based on evaluation groupings. And the Seventh Circuit found that to be an unconstitutional interference with that more senior teachers' rights that they had acquired when they acquired tenure. And obviously that means it's likely the Seventh Circuit would hold the same thing if Illinois' statute was challenged. So that certainly throws a wrench into things as we're trying to think about the fact that the very procedures we're required to follow have questionable constitutionality based on the Seventh Circuit, as well as the fact that all of those evaluation decisions that we made related to the pandemic are also going to have an impact now that we're going to RIF people. And as David and I warned pretty plainly in the fall, be careful what you wish for on the evaluation front, because when it comes time to make decisions about RIF, that could have some unintended or unforeseen consequences that are going to emerge now. So that's the other cloud that hangs over this conversation today for sure, is the cloud of Elliott.
Yeah. I remember we're in the Seventh Circuit, so Elliott governs here. And one thing that concerns me is that the way we've sort of averted trouble in the state of Illinois for the last several years, because remember, there's also an Illinois court case that goes before Elliott out of Peoria that holds that, in fact, the law is constitutionally founded. There's also a case out of Waukegan or North Chicago or something up there. I think very likely the Seventh Circuit interpreting the federal Constitution, the federal court interpreting the federal Constitution, is going to make the law in the state of Illinois. I think that probably trumps state court interpreting the federal Constitution, but be alert to the fact that there's at least some circuit disagreement out there. And so the way we've sort of averted trouble in the past is functionally by doing both, by putting people into groupings such that they, when you start to look at their grouping order, it looks an awful lot like seniority, and then not doing a RIF if we've got somebody who's going to be in a highly challenged situation, like, for instance, a teacher in grouping 2 because she got a needs improvement rating last year, who also happens to be a 22-year tenured teacher. We either find a way to get her into grouping 3 by changing the rules in our joint committee and then evaluating her into grouping 3, or if we're getting ready for a tenure teacher dismissal case, we get going on the tenure teacher dismissal case, because believe it or not, it is less risky to go forward with a straight tenure teacher dismissal case where I've got proof than it is to try and get them out the back door through the RIF process. And again, I just think that goes to the transparency of what we're doing here, is that we want to be direct with regard to what we're doing, going back to those old rules.
Yeah, and I think that's also one of the reasons why it's not just form work, but there's really some individualized decisions and some risk-taking analysis that needs to be considered as we walk through this. So let's walk through the nuts and bolts of the statute, first for teachers and other professional educator licensed employees. Then we'll walk through the requirements for ESPs. But let's start with just some of the nuts and bolts here. And we want to just, again, hit some of the key points and highlights for that. I will say I've had a couple questions about getting the PowerPoint. We will certainly get that to everybody. I will create a link here in a little bit and post it in the chat so everybody can have a copy of the PowerPoint as well, and we can send it in a post email as well if that's easier for everybody. So we'll do that here in a second. But let's jump in with our teachers and other PEL employees first. And the first thing I'm going to recognize is the timing of this. And so the timing and the form of the notice has been amended a little bit recently in terms of by permitting electronic mail to be one of the options, which wasn't previously there. So that's one of the ways in which some of your older forms or processes may be updated. But the requirement here is that it is sent by mail and also, so they're getting it 2 ways, right? That's what's important here, by email, certified mail, or personal delivery. So they receive it at least 45 days before the end of the school term, along with a statement of honorable dismissal and the reason therefore. And again, that's why it's not just popping in the form, because we need to be specific in the reasons in the resolution that the board adopts. And so that timing is 45 days, and that's 45 calendar days prior to the end of the school term is the timeline for getting that notice to teachers.
And it's important that the board keep a record that is adequate of when the notice was received by the employee. We've had a number of cases over the years. I had one real early in my career where the person got the notice on day 44 before the end of the school year. Now, the district sent it to the person several days earlier, about 2 earlier, 46 days, but the statute requires that they're actually receiving that notice. So again, when in doubt, multiples of these methods are a good idea. Make sure that you have the statutorily required mail, but also there's a reason that our advice historically has been do both, do certified mail and personal delivery. Go walk down the hall and hand it to them, because then you've got somebody who can testify to the fact, yeah, they actually received it. There's also, and with the certified mail receipt, then we've got a signature that they received it. But there's also good cause to do it early, because if you get tied up and you forget, a lot of the times I get the question, can I wait until the 45th day to schedule the board meeting? Well, yeah, but you're going to be leaving the board meeting and getting in your truck and hopping over to that teacher's house and handing them the notice in person that night. And you better make sure they're home and they're awake when you bring them the notice, because they've got to receive it on that day. Do these things early. The earlier, the better. And also, by the way, just from a management perspective, when you've got to hand it to the secretary and get her to put everything on letterhead, and you've got to have all the things signed that need to be signed, this takes a few days. You want to give yourself lots of breathing room to make sure that you do what you need to do.
And I would also just warn you, be careful in case you still have an earlier date in your bargaining agreement, because the statute used to be 60 days. And so there's still some bargaining agreements either that have the old language, or the union has bargained greater notice rights than the statute requires. So always pay attention to anything that might be there.
And board policy too. I found one policy last year that still had the 60-day timeline, and it just hadn't been updated.
A question on that. What do you do when the certified mail is not signed, but the receipt is returned? That's happened to us a few times this year with important documents. Well, I know that right now, the Postal Service has some different COVID procedures for certified mail where the delivery person signs that they delivered it as opposed to the recipient signing that they received it. So long as we get that, I think it's still there, but recognize that certified mail, we could also do email or personal delivery. So if we're worried about whether certified mail is getting there, then skip certified mail, and now we can do email or personal delivery. And that addition of email this year to the school code, I think will be helpful for us. I think it was added really as a COVID related addition, but is permanently in the school code. So I think that will be a helpful way to make sure we're getting stuff to people. And then we've got an email to show we sent it and the day we sent it. So I think that's important for us.
Yeah.
So this sequence of honorable dismissal list, well, always one of my favorite things to think about and teach about, and that makes things difficult for us. But we are required annually to create a sequence of honorable dismissal list where each teacher is categorized into the positions for which they're qualified. Those qualifications have to be established annually, at least May 10th of the year prior, right? In terms of how we are categorizing those positions. And if we haven't changed anything, then I think the status quo prevails from what we did in our previous sequence of honorable dismissal list in most situations. And then we put those teachers into 4 groupings based upon the statute. So before we jump into those 4 groupings, David, any thoughts on the big picture in terms of the sequence of honorable dismissal list?
Yeah, early on, I think certainly I had the opinion that May 10th list was a list of where everyone was. And I think that the prevailing wisdom now is not so much that it's a list, unless it needs to be, but rather what's the minimum qualification for the position, which is really endorsement licensure. Because remember, at the same time this happened, there was this gigantic change to 21B of the school code, which changed the way endorsement licensure occurred. And because there was this big change, before there were just sort of general licensures. And so we could take the position that somebody wasn't qualified because they haven't taught math in 23 years. But we took that position during the time we were doing the RIF. Now you have to take that, if you're going to take that kind of a position that the person isn't qualified, it's got to be established by May 10th of the year prior. Practically speaking, if they're licensed and endorsed for it, in most districts, that means they're qualified for it. So it is important to make sure that we are taking a look at where people are qualified, because that's what's going to determine ultimately how we do those bumps. Remember that although you may be taking the position after having listened to us talk about Elliott, you may be taking the position it's just reduction in force, it's no big deal, we're going to do it by seniority, we're going to ignore Elliott altogether. Remember, you still have to get that list out. The list is still in the statute, as is the seniority list. So you still have to get those lists out, and that means that even if you're going to ignore them, they still exist. And it may be predicate to the dismissal itself.
And of course, that list has to be out at least 75 days before the end of the school term. So really that gives you, when you think about it, a 30-day window between when the sequence of honorable dismissal comes out at least 75 days before the end of the school term, and when the RIF notice has to be received at least 45 days before the end of the school term. That's where that is at. A couple things that are also important is that copies of the list has to be provided to the union, and it must specifically show each teacher by name. And that is an important piece, because originally we had lots of conversations about, do we use secret codes? And there was confidentiality considerations. And the statute was subsequently amended to make clear that the list that goes to the union shows each teacher by name. And I think that I still have some districts that try and use secret codes and numbers, and we need to recognize that the statute makes clear that it must be by name.
And to be clear, I think you can still use the secret codes as long as they've got the key and they've got the list with the names. They do have to have the list with the names. But they can get both. They just can't get the randomized list by itself. And that's really important, because the union is entitled to information to represent its folks. So you risk not only a grievance, but or a lawsuit under the law, but also an unfair labor practice. And I have had some districts that got threatened with those when they refused to disclose those names. You're not breaching any privacy by giving them the names, but also remember, I think a lot of the reasons school districts still do that is because they're concerned about those groupings lists getting into the hands of the remainder of the teachers. While that's not your responsibility necessarily, it's okay to do a secondary list and give instructions about what your intention is with regard to the disclosure, that if you're going to share it, use the number list, but here's the list with the names so that you've got all the names.
And so I know, David, we've got several questions. I want to run through pretty quickly a couple of these specific things in terms of the statute, and then I think we've got some great questions I want to go through on these teacher pieces. So I'm gonna run through some of these really quickly, and then maybe we can come back and hit the high points through the questions that we're getting. Just again, grouping 1, 2, 3, and 4. Grouping 1 are non-tenured teachers who have never been evaluated, who is employed for 1 school term or less to replace a teacher on leave, or is employed on a part-time basis. The order of dismissal within grouping 1 is at discretion unless otherwise bargained. But keep in mind, even somebody who's employed for a short term is still a grouping 1 person who must still be RIFed. So when you're employing someone to fill in for someone on leave for less than a year, they may still be entitled to a RIF notice per school code.
And remember that although the code says maybe RIFed at discretion, I know of a lot of collective bargaining agreements that provide an order and accumulation of seniority during that period. And that accumulation of seniority, if it's incorporated into the contract, is what your discretion is. It's to comply with the contract.
So grouping 2 are those teachers who had a needs improvement or unsatisfactory on either of their last 2. And within grouping 2, the order of dismissal is based upon their average performance evaluation rating, with the lowest dismissed first. Grouping 3 is what I call the default grouping. It's where everybody goes unless they qualify for a lower or a higher grouping. And ultimately within grouping 3, the order of dismissal is by length of continuing service, unless we've got an alternately bargained process. And then grouping 4 are those teachers who their last 2 or 2 of their last 3 were excellent. And again, within grouping 4, the order is by length of continuing service. Again, just keep in mind, school code has some additional details about those. That's the high point of those, as well as decisions of your RIF joint committee or bargaining agreement certainly may affect the order of that. But that's the big picture view from the sequence of honorable dismissal list. The other piece here quickly is the school code also requires, in addition to the sequence of honorable dismissal list, a separate seniority list, which is simply a seniority list that also has to be distributed at least 75 days before the end of the school term in that regard. And then in terms of recall rights, it's within 1 calendar year from the beginning of the following school term, unless you've had a significant number of RIFs where you're riffing more than 15% of your staff, then it goes to 2. And in grouping 2, there are limited recall rights that don't go as far as 1 year, of course, unless you've bargained a longer recall period in that regard. So, and then one other quick notice here before we go to the big picture conversation is this public hearing piece. And I think this year is one where this public hearing might become very important. So whenever our number of teacher RIFs or PEL RIFs exceed 5 total notices, or 150% of the average over the last 3 years, whichever is more, then we also have to have a public hearing prior to board action on that RIF. And because a lot of us have had a relatively low number of RIFs lately, if we are going to have 5 or more RIFs that we think we're going to be given to PEL employees, that we can't overlook as we schedule out the timing of this, the requirement for a public hearing. So let's go back and let me ask some questions here, David. So I'm going to just go through some of these questions that we have on these issues, and I'm going to start at the top of these and ask away. If a teacher gains additional certification in the year they have recall rights, can they then bump a teacher with less seniority in another department?
So that's a tricky question right now, because of course we've got that May 10th qualifications delineation for what the positions are. That doesn't necessarily refer to the person's qualifications. One of the things that I'm concerned about when we start making when people acquire midterm qualifications is that a lot of folks within the school system are presently teaching on various waivers and other such things. And so when they acquire the licensure, I think the answer is you can't dismiss them for want of licensure. And because you can't dismiss them for want of licensure, the long version of my reasoning, I also think that means that their bumping rights are protected as a function of that licensure. So yes,
I agree. I think that additional licensure the year of the RIF, but I guess the question here is, this is somebody who's been RIFed and is out there on recall, and now they get additional licensure. I don't think they bump anybody at that point, but I think their new license could count for recall. So if they, let's say for example, gained math licensure during the recall period, and now you have a math opening, I think that you would have they would have a right to recall, but I think that they're going to have to give you notice that they have that licensure in order for that recall to be.
Or you're going to have to be on notice. Yeah. And I'll take that one step further. Let's assume now that it's a non-certified employee, because the statute for non-certified employees also says any position for which they're qualified. And I think that's a lot of the purpose. I don't mean to digress into non-certified staff, non-licensed staff, but I think that's a lot of the purpose of 21B, is to establish those different criteria for different positions, thus allowing somebody who's appropriately qualified, appropriate licensed for that position, to come back into any position for which they're qualified.
So here's a question I think helps us go back to the big picture: dismissal versus RIF. If we decide to dismiss rather than RIF a third-year non-tenured employee, are we required to give reasons? Well, I'll take the first stab on that. We're required to give reasons for a dismissal of a probationary employee in their final probationary year. Historically, the final probationary year has been year 4. And so historically and typically, a third-year non-tenured dismissal would not require, I'm going to come back to whether we should, not require reasons be given. However, because the tenure statute now has staggered potential periods for acquiring tenure, it is conceivable that somebody's third year is their final probationary year if they've had 3 excellents and Although if we're dismissing a teacher who got an 3 excellence, that raises a whole nother set of questions in my mind. But the statute is for a dismissal of a probationary employee, we must give reasons in their final probationary year, but that final probationary year might be year 2, 3, or 4 based on the new tenure acquisition statute. Now, we need to make sure that we have reasons, because when we're dismissing somebody, we can just assume that we're going to be sued or for discrimination or some other complaint. So we better have reasons, and they better be consistent, non-shifting, non-pretextual reasons, but real documented reasons that we are not adding to or changing down the road. And that's why the documentation on those dismissals are so important. I think that idea that we can just, they're a third-year non-tenure teacher, we can let them go for no reason whatsoever, is a little bit short-sighted, because you still have to be able to defend a claim of discrimination or some other type of charge.
Yeah, remember that the statute says you don't have to provide cause. It doesn't say you don't need to have cause. You have to be able to defend why it's not a pretextual reason, just as Brandon said. But I want to add one step further, which is that when I draft up my resolutions, a third-year non-tenure teacher, if I'm dismissing them or riffing them, my clauses look totally different. My resolution looks totally different. In fact, even the notice that goes on the agenda looks totally different. I cite 24-11 or 24-12. I'm going to identify my 24-11 resolution. If you're looking at references on other teachers, take a look at the resolution. If it's 24-11, if it's a cause-based resolution, that's frankly my code for cause. We don't want this person anymore. There is cause here. We're not going to say it in the resolution. We're not going to make it public, but for whatever reason, they weren't a good fit here. And that means you've got to have cause, and you've got to be able to prove that cause. And that's where those evaluations are really important.
So David, if I added a teacher's aide this year, particularly for COVID, and I don't plan to need that position for next year, do I need to RIF this position?
Yes.
Yes.
Yes. I think anytime we reduce somebody's hours, anytime we reduce their pay, anytime we reduce their expectation as to employment, yes, it's clearly a RIF. And to be clear, that goes for everybody, even if we're just taking somebody down from 5 hours to 4 hours, even if we're getting rid of somebody who had no reason to expect that they're going to be here next year. The statute doesn't say with a reasonable expectation of continued employment. It presumes one. In other words, it is our duty to cut off that expectation. Now, I recognize that sometimes we hire folks without an expectation at all, like, for instance, a substitute, a day-to-day substitute. They have no expectation. So if the statutory definition of the employment is that they have no expectation, then I don't think you've got to conduct a RIF, but I absolutely do if there's any statutory expectation at all.
So on the broader RIF question, this is one question I get a lot, and I think that often confuses people. Which comes first, notice to the employee that they're going to be RIFed, or a resolution approved by the board? Go
ahead.
Yeah, I mean, the issue is the official notice can only come after the board resolution is adopted. So while it certainly can't hurt to give the employee informal notice prior to the board acting, that does not count as notice of the board action required by the school code. That formal notice comes after the resolution is approved by the board.
It's written and it's statutorily defined, but I'm going to go one step further and I'm going to add a third in there. First comes the union. Union first. Before the board, before the employee, union first. Employee is second in my mind, if only because what I don't want to have happen, when I've got a non-renewal, a dismissal for cause, the employee is the first person I'm letting know. And the reason is practical. It's not legal. I want them to go find another job, because the best medicine for a lawsuit is pay. If they're getting, in other words, the best remedy is that they get another job. If they're getting paid by someone else, they're not likely to come sue you. Not impossible, but not likely, particularly because generally speaking, they're only going to get the gap of those two pays. And if they're earning more, they're not often going to be able to recover the entirety of the salary that they missed working for you. You want them on the market as early as humanly possible. And that's why I do want the employee to get notice as early as possible. Nothing to hide.
And that's the step-by-step we have here on this slide. Notice to the union, board approves resolution, then that formal notice sent to the employee.
Yep.
If a principal has tenure in the district prior to becoming an administrator, and then continues to have 1-year contracts, do they go on the seniority list or the sequence of honorable dismissal list? Yes.
Yes, and whether or not they've got tenure, the statute was amended in the first trailer bill to require that administrators are placed on those lists. So yeah, they do go on that sequence of honorable dismissal list.
Several people have asked about current year evaluations and their effect. So we know that list has to go out 75 days before the school year. Do we count this current school year's evaluations when we're creating that list? And the statute actually anticipates that. And so I think that the answer under the statute is yes. For any evaluations that were completed by the time the list goes out, they absolutely are considered for purposes of creating that list. And then anything that comes out after that won't count for the next year unless it would be enough to move somebody out of grouping 1 into one of the other 3 groupings. The statute says you can, in that period between 75 and 45 days, if an evaluation is completed for an employee, that might move them out of grouping 1.
Grouping 1. But remember also that there's the COVID statute, for lack of a better term for it, that changed 24-12 to provide what amounts to a default ranking for folks for purposes of that grouping list. So if you didn't get an evaluation done at all, there is a default rating. Now that rating historically has been proficient, which, absent another rating that moves them into grouping 4 or grouping 2, would functionally put them in the default grouping 3. But this year, because if they got an excellent last year, then they would also be getting an excellent this year for purposes of the statute because of the ongoing pandemic.
What does it mean if we have not had evaluations due to COVID for grouping 1? I mean, if a non-tenure teacher has never received an evaluation rating, they're in grouping 1. Otherwise, if they qualify for another grouping, they go in another grouping.
That's right. And remember that you've got, I mean, again, we've got that automatic rating system in 24-12. And again, I mean, this, not to beat the drum, but this is why this stuff is so complicated every year, because you get a new statute and the new statute changes interpretations. That new statute sets forth a default grouping rating for anybody who wasn't, a default evaluation rating for anyone who wasn't evaluated. And of course, a lot of you have agreements that you reached with your unions along the way to establish that that rule is the rule for your district, because that law comes down in June or thereabouts. And then a lot of districts signed agreements with their unions by August. And by August, you'd establish basic ratings for folks. Now, the good news is it's at least going to remove some question as to whether or not your seniority works.
So for everybody's purposes, we definitely want to talk about ESP RIFs because they are different. And we want to hit some of the other key points that are out there, like some of the Open Meetings Act and other issues that come up. But we've got a ton of great questions. So we're going to try and move through them as fast as we can and still answer the questions so that we can really make sure we still have time to talk about ESPs and those other issues. But question now, is there a number of days that determines whether a short-term teacher must be in a group, like 120 days? And I think sometimes that's because the statute previously used to have a November 1 date that's no longer there in terms of being employed by November 1. So at this point, the issue is, as David said earlier, I think, are they employed as a day-to-day substitute, or are they employed to fill in for a teacher on leave for less than a year's term? Then I think they clearly are someone who we would have to consider for RIF purposes.
And remember, 120 days is the number of days they've got to be on the ground to accumulate a year toward tenure. If they're on the ground 120 days, they accumulate a year. If they fail to, or anything less than 120 days, they don't get a year toward tenure.
But they might still have to be RIFed.
Correct.
There's not a magic number in that regard. Group 1 has no
Correct.
recall rights, correct? That's correct, unless you've bargained it in.
And a lot of districts have without necessarily doing that intentionally. They define seniority accumulation for all employees, including part-time employees or first-year employees, and that effectively gives them recall rights in that first year.
Do you need to have a public hearing if you are riffing a single teacher? This is our first RIF in over 5 years. No, the issue is if it exceeds 5 or 150% of the average, whichever is more. So if you haven't riffed anybody for the past 3 or more years, then the greater number is going to be 5. So if you're riffing 5 or more, or actually it's more than 5, if it exceeds 5 notices, then you're required to have a public hearing. Are they business days or calendar days? It is calendar days, unless you have bargained something different in your contract. Is lack of funding a reason? And is that the reason that if we get more funds, we can rehire? Yeah, but generally these are lack of funding or uncertainty of funding is oftentimes the reason that we give for a RIF, and recognize that someone who is RIFed would have recall rights. So if then you decide to fill that position during the recall period, then that person presumably would be recalled into the position.
And that's a straight reduction in force. It's not a dismissal for cause, it's a straight reduction in force. It applies with recall.
When you do go to the board for the RIF, cause or not, although I would say RIF is, because we're reducing the number of employees, dismissal for cause. So I want to make sure that we are not using RIF interchangeably there. When we go to the board for this action, are the names needed on the agenda? And we're going to get to the Open Meetings Act issue here in a little bit. I think names must be, the agenda item has to be specific enough, and names must be in the motion, but the name is not required to be on the agenda.
I agree. But I do think that the positions, generally speaking, need to be clearly established on the agenda.
Yes, I think the position, yes, the individual's name doesn't have to be specified on the agenda.
Agreed.
If we have hired a retired teacher as a full-time teacher under the new shortage area provision, do we have to RIF them? The legislation is written to my understanding that this is a year-to-year position where we have to make a good faith effort every year to hire a non-retired teacher. And we won't know until the summer whether we've been able to replace them. My answer on that has been yes.
Yeah, I was going to say, so notwithstanding the change of the statute, the part-time retired teacher business, I recognize we're talking about full-time under the statute, but the part-time retired teacher business has been out there for a long time. My answer has always been better safe than sorry. I'd much rather we take the action and the reduction in force because it's not harmful. It doesn't do any harm to the district. It doesn't do any harm to the employee. It's clearly for financial purposes. I would certainly rather we don't end up with 2 employees. And remember, by the nature of their experience, a lot of these folks are also folks who could fall into any number of protected classes and thus have available to them a very easy complaint should they wish to file it. Whether or not it's statutorily clearly required, my answer is going to be I wouldn't want to take the risk and not do it, because doing it is cheap. Failing to do it could be fatal, meaning you could end up with 2 employees for the year and the cost of the lawsuit to deal with it.
I agree. If we're releasing a teacher, can we give them the option to resign instead of being terminated by the board? Are there legal concerns with giving them the option to resign? I always think an option to resign is the right answer and the path of least resistance. It could still be an issue where someone could claim that it's still constructive discharge, for a discrimination claim or other things, potentially based on various factors and contexts that may apply. But I think in almost every situation, a resignation is preferable to board action for termination for both parties.
And procedurally, one thing I worry about when we do that, I agree 100%. I'd much rather if the employee can resign and protect their own name going forward. A lot of people who are dismissed after a year or two in a school district are really good teachers that just haven't figured out yet, or are in the wrong content area or in the wrong place. Good fit somewhere else may not be a good fit here. I get that, and therefore a resignation is great, and it's great to offer that as an option. And if you rely upon that, it may be irrevocable. But a couple of things to be alert to. First, when they resign, sometimes they can come back and say, oh, no, I just kidding. I revoke that resignation. So be alert to the fact that if they're going to resign, you're going to want to make sure you do something to make it irrevocable. Maybe that's posting the position, maybe that's board taking action, maybe that's any number of other things you might do to try to make it irrevocable. The second thing is don't put them under duress. One thing I hate is the employer who sits down, writes out, I hereby resign, puts the person's name in print, turns it around, says, sign this. You're in my office right now, sign it. When I've had situations and investigations where we've tried to coax a resignation from someone, I have always said at the end of the meeting, please, we would like you to resign. Otherwise, we're going to take board action. But please go home and think about this. I don't want you to do it this second, because I want you to have some time to process what just happened, because I want that resignation to stick. I don't want that to go out the window. So be careful about duress.
All right, 2 more questions before we jump in and talk about the differences with ESP RIFs. First, if we've got an interim position like an interim principal that were filled at the beginning of the school year, do I need to RIF them as I fill the principal position for the upcoming school year? Well, without getting on a totally different track, I think there's a whole different process. Even if you've called them an interim principal, you've got issues of what does the contract say, the reclassification rights potentially of a principal or assistant principal or other administrator, as well as the RIF or non-renewal process. So because also, do you want them to have recall rights? Is that a RIF? Is it a reclassification, or is it a dismissal? And I think all of those are going to be sort of dependent. I think that what we have to clearly understand is that the way the school code is written, it's not like people just go away when we do nothing. And I think that's something we have to recognize, is there's going to have to be some sort of affirmative action. Either they are resigning or there is board action, and the timing of that could be important under the school code. So be careful of thinking that people who are operating in these interim or other capacities just sort of automatically disappear without a claim to continued employment.
Yeah, look out on the principles, the great big shining light on that word that Brandon just used, reclassification. Anybody who's been in the job a year has a right to reclassification. So our process that we've been talking about here on our certified staff only in part applies to principals. There's a whole secondary process that has to intercede, that has to start before you can get into this process. So that's one thing we're not going to get into very deep today, is we're not going to talk about that process that goes ahead. And if you're not in that process and considering that process already, there is no better time than yesterday to start working on that reclassification process, because it has a lot of steps. It's procedural. It's not a huge substantive burden, but there are a lot of steps to it, and you got to get those going pretty quick.
All right, David, one more question before we jump into ESPs, and that is, do we use the default evaluations from this year on this year's list, or do we wait till next year's list? My view on that is that in part depends on what your agreement with the union is. And I might go back to that. I think this is also inherently part of the problem of this idea of the default rating, is at what point does it actually attach and become the person's rating? And that also may be a component of your evaluation plan, the deadline for issuing evaluations under your evaluation plan, and the specific terms of your MOU.
Yeah, and I mean, not to harp on the subject, but Brandon, you and I know talked early on when that law was passed that both of us were a little concerned that the law changed 24-12, but didn't change 24A-5 or 24A-15 at all. In other words, there was no waiver of the duty to evaluate. And in fact, while there were a whole bunch of groups that said, well, this means you don't have to evaluate, there was also the State Board of Education that said, wait, we didn't say that. their statement and said, we do want you to focus on formative assessment. We do continue to want to do some degree of assessment. So while you made, I mean, I don't want to oversell the likelihood of risk there. It does create a little bit of complication with regard to what we do about ratings and what that means for purposes of dismissal.
All right. Well, let's jump in and talk about ESPs, because under 10-23.5, there are some specific differences. And so I'll highlight those quickly and then we can talk through them. Again, this applies to all ESPs, not just those in a bargaining unit, as we said earlier. So I think that's a common misconception that we only have to worry about RIF and recall for employees that might be in a union. And it applies to all of our ESPs who may have a right to that. The timing is very different under the school code in terms of the timing of notice. It's a 30-day rolling notice. And so it's not 30 days before the end of the school term. It's 30 days before the effective date of their dismissal or reduction in hours. And so recognize that that could happen on a rolling basis throughout the year with 30 days notice. That's a 5-day notice if the reason for that is an unforeseen reduction in the student population. But also pay close attention to stricter notice provisions in a collective bargaining agreement. I still see a lot of CBAs that would tie that 30-day notice to the school year or have a longer notice akin to those of teachers. So pay close attention to anything stricter in a local bargaining agreement or policy.
Yeah, the 30-day rolling notice shortens the degree of risk. Obviously, you only got somebody on site for 30 days. One of the things I get a lot is, as a question is, but what does that 30-day notice really mean? And the answer is they're entitled to 30 days pay and credit. But remember, credit means whatever they're doing. Well, but there's nothing for them to do in the 30 days. Well, sorry, that's what the statute says. They get pay and credit for those 30 days or 45 days before the end of the school year, if that's what you bargain with your collective bargaining agreement.
Also recognize that the timing of the seniority list for non-certs is sooner than that for teachers, and it's a February 1 deadline. And so that is coming up very soon. So make sure you're getting your non-cert or ESP seniority list by February 1, categorized by positions. And again, it's for any employee who is qualified to hold that position. So you could have an employee who is on multiple lists, but that their length of service is that length of service in that position. And so it is a very different process where we're looking at the length of service within that respective category of position. So the order of dismissal is the length of service within that category of position, not the length of service with the district, but their length of service within that category of position, unless you have an alternate method through the collective bargaining agreement. So this is an area where, again, you want to look closely at your seniority list, your past practice, and any bargaining agreement language when we're looking at the order of dismissal for laying off non-cert employees.
Yeah, be careful with that retention of seniority stuff, because particularly in larger districts, there are really complicated rules about who goes where and who retains seniority where and by how much and who they can bump. And those things need to be sussed out every single time you do a RIF on the positions you're getting rid of. And that may mean that if you're getting rid of a category of cooks, for instance, some cooks are going to become bus drivers, some are going to become secretaries, some are going to become aides. Some are not going to bump anywhere. But again, this is a place where I look very closely at who's licensed to do what, because of course there's licensure for food service, there's licensure for bus driving, there's separate requirements for some positions. But again, I'm looking to what's already there pre-existing, because one of the questions I've gotten before is, well, but this says they can bump to be a bookkeeper, but there's no way I want this person as my bookkeeper. Well, if your collective bargaining agreement allows them to bump into any other position, that's where you're going to end up. And so we may be looking at some sort of tough factors. And that's why we've got to make those decisions early in the year about where we want people to be able to go.
And relatedly, while RIF is within the category of position, recall rights for non-certs are cross-categorical based on their qualifications. So if we have any vacancy for any position for which they're qualified, so you lay off a teacher's aide, but they're qualified to be a cook, or you lay off a teacher's aide, but they're qualified to be a secretary, and you have a vacancy within a year, then they would have a right to recall into that other position for which they are qualified to hold based upon the existing job description and qualifications for that job.
Yep.
The school code was also amended last year to extend the same rights ESPs that exist for tenured teachers, that if an employee is recalled, they maintain their rights accrued under previous service, presumably their seniority rights, among other things. So just recognize that that is also now in the school code for recall rights for non-certs. So again, just by way of recall, the timing of the seniority list is earlier. Same issues of bargaining if there is a bargaining unit for your non-certs. That notice is a 30-day rolling notice unless you've got a different collectively bargained provision. And so keep that in mind. Remember, for ESPs, it's RIF by length of service within the category, and recall is cross-categorical based on qualifications. So some additional things we want to make sure we're keeping in mind when it comes to issues of RIF. Of course, one of those very importantly are Open Meetings Act. And so we touched on this again a little bit earlier, but remember, we've got to make sure that we've got specific enough action posted on the agenda for that action. And I still see this to be an area where districts, I think, sometimes don't get specific enough with their agenda, and they have very generic, vague, like personnel action, and that is definitely not going to cut it in terms of being specific enough. And so we need to make sure we've got that very specific agenda item. As we said earlier, I think it should clearly say reduction in force of professional educator license employees or reduction in force of educational support employees. I don't think it is required to have the name of the employee on the agenda. I think the name must be in the action that the board, in the motion, when the board takes action. But we have to have a very specific agenda item in order for that to be appropriate. And remember, that's important because if your action is determined void because it wasn't properly posted on your agenda, with most things we could just do it again, but with a RIF where the timing is important, we may have blown the timeline by the time it's declared void by the public access counselor, which means that person's getting their job back and getting back pay potentially. So that's why the Open Meetings Act compliance here is extremely important with the agenda and action item.
Yeah. And again, remember the purpose of the Open Meetings Act is that the public is reasonably apprised of the action that would be considered. There was a public access counselor opinion a couple of years ago that dealt with the board taking action on a kind of vaguely put notice and then having no discussion before they took the action. There's no public participation. There's no discussion. They just went and went, and that's not enough. There needs to be sufficient information on the agenda as to what you're doing, specificity as to what you're doing. Is it an honorable dismissal? Is it a dismissal for cause? Is it a professional educator license position, or is it a non-certified position? You need to make clear what it is you're doing. And then there needs to be discussion about what that actually is before you actually take action on it.
And that discussion is going to generally be open session discussion, right? So that's the other piece here, is that the PAC has been very clear that discussion of RIFs are not permitted in closed session, because RIF is about the decision to reduce or eliminate a position, not a specific person. It's not considered the appointment, employment, compensation, discipline, performance, or dismissal of specific employees, because it's about eliminating a position, not eliminating the person. And so we've got to be very cautious about those discussions happening in closed session.
Yeah, every year when RIFs come in, folks who've dealt with me regularly know that one of the first questions I ask is, does it have to be them? Or can it be anybody with a math qualification? And if the answer is, well, it's got to be them, then we're talking about specific performance of a specific employee. But if you answer the other way, the consequence is this isn't it's got to be them because I already talked to the board about it in closed session. No, that's not a RIF discussion. That you're acknowledging it's not a RIF, and now we're talking about a dismissal.
Also, just a quick reminder here on your RIF joint committee, separate from your para joint committee, your RIF joint committee has to meet annually. They got to have their initial meeting by December 1 of each year and reach any agreements by February 1 for it to have effect for this year. And remember, the RIF Joint Committee is about setting the rules. They're not the ones who determine the placement of specific individuals. So they've got some very specific but narrow authority about how you move in and out of grouping 2 and grouping 4. And they set the rules for those, right? They don't say, should David Braun move into grouping 4 because we like him? Or should Brandon be moved down into grouping 2 because we don't like him or whatever? It's about the rules, not the people.
And Brandon, this issue's come up with me a whole bunch this year. A question I've gotten a whole bunch this year is we didn't have our meeting by December 1st, but there are probably going to be RIFs. I think it's fair to say that at this point, there's some risk there. Mm-hmm. But I also think here we are still before February 1st. If we're going to be looking at conducting RIFs, and I recognize that to give the answer, you should take no risk, it would be catastrophic. There's no way you can do a RIF this year. Could be a catastrophic situation for a school district. So if you're willing to take the risk, to assume some of that risk, one thing I've noted is, at least for argument purposes, now that we're past December 1st, if you asked me this question November 1st, I'd say have the meeting by December 1st. It's easy.
Right.
But all you got to do is sign a form that you were there. That's all I care about. But now that we're past the deadline, if you haven't done it and you're willing to accept some risk, I think there's at least a conceivable argument that the opportunity to change the rules before February 1st hasn't gone away. So if the union is agreeable to having a meeting, if the union is agreeable to not making changes, meaning you're not going to make any changes from what you've done in previous years, there's at least a viable argument, a viable defense that they had time to make changes. They chose not to make changes. And therefore, December 1st ought to be viewed by the court as directive, not mandatory. That said, no court has ruled on this yet. So we don't know where it's going to land. And so you are taking that risk if somebody's upset. You disagree with any of that?
I agree. And so to the extent we can have clear, if we missed our December 1 deadline, clear agreement or waiver from the union, I think would go a long way to cure that. Otherwise, I think the other option is to just don't make any change. And whatever you had the prior year is going to remain in place. And we're just not going to make any change for this year. I think those are things that we want to keep in mind. And then, of course, we're left to the impact of the pandemic on this. Obviously, that's the reason why we're even having this discussion, because we think that the pandemic is going to have a significant impact on our funding and our budgets. So we've got to be prepared for it. But I think those evaluation pieces are going to be important. And I know, David, we've talked about this already, so I don't know that we need to belabor the point again. But I think that we're going to have to, on a district by district, case by case basis, look carefully at what you decided to do this year and how that may impact, sequence of dismissal, the impact of Elliott, and all those things combined into one, that it's not a matter of just filling in names on a form.
And look, if we get really lucky, your evaluation ratings and your seniority list are going to end up looking the same. And then we're just riffing in seniority by qualification. It's not easy, but at least it's consistent. And consistency will make things a lot easier. That said, still be alert to the fact that 24A-5 does still say evaluate annually.
So before we move on to see if we want to have questions about other topics before we close out here today, as we've got about 10 or 15 minutes left, we've got a couple questions that have popped up. So a couple things here. One, is it necessary to hold a RIF joint committee meeting for ESPs, or is that only necessary for teachers? And right now that is only required for teachers unless you've bargained that process in for non-certs.
Right, the RIF Joint Committee, but I want to segregate between the RIF Joint Committee and bargaining. So the RIF Joint Committee is only necessary under 24-12 for teachers, but the discussion of RIF or bargaining rights of RIF apply to ESP unions as well. And therefore, before you conduct a RIF with an ESP, if there's an ESP union, you do need to have that bargaining discussion with them, or at least that notice discussion with them. This is what we're going to do before the board takes action.
So a question here, an employee gets a stipend and they're the only employee in that category who gets the stipend. And we want to eliminate that position and move a less senior ESP into that position. Do we have to RIF them in order for them to not get the stipend? Well, I think there's a couple layers there. First of all, if they're already within the same category as other people, then somebody else is going to get RIFed and not them. Now, if you're just eliminating the stipend piece, you can eliminate the stipend and nobody gets the stipend. But if you just want to move them out of the stipend position, move somebody else into the stipend position, that's not a RIF. That's a for cause dismissal from the stipend position.
Yeah, and with regard to the stipends, the whole how does seniority relate gets complicated in terms of what the stipend's for, what the work is, what the collective bargaining agreement says, how much risk you're willing to assume. But one thing that I want to be really careful about is, yes, we do have to conduct a RIF if we're removing somebody's work and attendant pay. But if we're doing that and then hiring somebody else in, remember, recall rights still at least conceivably apply to positions. And therefore, if we're going to move somebody else in, that starts to sound a lot like cause.
Public hearing is only for PEL, not ESPs, correct? That's correct. The public hearing requirement is just required for PELs under the school code.
If there's 5 or more, 150%.
Right.
Not for all RIFs for PELs.
So before we totally shift gears away from issues of RIF, first of all, anybody else have more questions on RIF that we can talk through? Or David, any other thoughts or points of emphasis you want to share before we maybe shift gears and quickly mention a few other legal issues that are out there for us to talk about?
I think the biggest and most important one is start your work on RIFs early, and don't be afraid to have a conversation with the union well before you get authorization from the board. One of the mistakes I hear all the time is, I don't want to talk to the union because my board hasn't authorized me to do this, and I don't want to create panic. They wait for the board to make up their minds. And of course, the board routinely is looking for leadership themselves. And so they get there and they kind of debate, and they're talking about people. And of course, they're supposed to be doing this in open session, not in closed session. Routinely, they do it in closed session. And then they get into the people, and that's not a RIF. That's a dismissal for cause discussion. And that, honestly, guys, that monkeys up your job. It just makes your job tougher. Start with the union. Go ahead, even if you haven't decided which positions. Look, I know I've got to cut $128,000 from the budget. Somewhere I got to find $128,000. And I know that I don't really need this position, and this position. These are the ones I'm thinking about, but I could also be these other 4 positions, or maybe 3 people out of this category. I have that discussion with your union. Start there, because if you do, you will start to see the roadblocks coming before they get there. Then go to your board with these are the positions, and we're doing it in open session to prevent them from talking about people. That helps you. It doesn't harm you. It makes it easier for you, because now they have to stay focused to those positions, because they can't be talking about their neighbors out in open session. That will help you, I think. And I think that will also help you distinguish between a RIF and a dismissal, because we're in closed session and they're talking about a specific person. We better be looking at their evaluation.
That's right. And so again, the question here, RIF discussion should not be in executive session. Correct. That's correct. It must be an open session. Discussions about RIF are open session discussions. And regardless of whether we're going to RIF or not, the RIF Joint Committee is required to meet annually, correct? Yes. So they're still required to meet annually by December 1. That is the requirement of the statute, even if you're not going to RIF. I would say for the last few years, there hasn't been a lot for those committees to talk about. And frankly, even if you've got your rules kind of set, there may not be a lot for them to talk about, but they're still statutorily required to meet. And that is a mandated procedure to get to a RIF.
Yep.
Well, I think that kind of lets us now talk about any other questions or issues that we want to think about. So please don't be shy about asking questions on this or any other topic in the chat box. I'm going to throw one out that is not RIF specific, but certainly I would say we've got two questions that have been one of the hot topics for the week. One of those is vaccines and the other one of those is athletics. So which one do you want to talk about first?
Let's start with vaccines.
Yeah, I mean, I think the good news is I'm hearing that some of your staff are already this week being able to get vaccines in certain counties, and that others of you are going to be soon behind that. So that's awesome. I'm jealous. Sign me up.
Please.
My dad last week, my parents live in Florida, and they're doing first come, first serve, and he slept in his car overnight with a bunch of other 70 and 80-year-olds in 30-degree weather to be in line for the vaccine the next morning. And he got his first shot. So very excited I might be able to get to see them in coming months once that rolls out. But yeah, I think that we're there. I think that what we want to recognize when it comes to that, the question we usually get is, mandatory versus voluntary. I think right now I've seen almost universally it's voluntary. The EEOC put out some guidance about mandating vaccines, and but even in the healthcare industry, we're not seeing that being mandated by and large. In part, I think because it's emergency approval use and it's not so widely available that somebody could just go get it. And so I think that we want to encourage staff to do that. Work with our local health departments in that regard, but it's exciting to see that a lot of school staff are being rewarded with getting to be high in the line on that.
Yeah, and another interesting note right now too. So first, my wife got the Moderna vaccine last week. She teaches at the university, and we were really glad for that. But she got real sick afterwards, which we've heard is fairly common, and also a blessing, we've been told. But we found out this week that the Moderna vaccine is on hold in the state of California because of a bunch of really serious allergic reactions. So one thing that I'd caution everybody is, remember, it's still really early and these things are going to change really fast on us. So go slow. But remember also that EEOC's guidance said that technically their opinion is, yes, you can mandate if you do it as a part of the job and subject to collective bargaining issues and disability issues. What I've told people is, and they've asked the question, if you're asking me, can I mandate it today? My answer is, how are you going to have a school open when nobody can get vaccinated? I can't get vaccinated, at least not to my knowledge. My wife, who's actively teaching right now, has only one dose in her. She's not vaccinated yet by definition under the CDC's guidelines. And second, there are lots of people who may not be able to take that vaccine at all, that there are lots of studies that haven't been done on the vaccine for certain groups. And so you're going to walk yourself into a bunch of disability issues and a bunch of bargaining issues. Down the line, that may be a viable approach. I think that may be a viable approach when we have broad access to the vaccine, when we are struggling to get herd immunity and we have a large percentage that's already taken it. We're talking only about a very small percentage that are refusing to do so. But again, when we do that, we're going to run into collective bargaining. We're also going to run into disability issues. We've got to deal with each of those one by one as they come up. So for now, just to the extent that we can get those vaccines in people, that, boy, anything we can do to encourage it.
Absolutely. So let's talk about sports. I think the good news
Duck.
is many of our regions are starting to be able to move up the tiers, which is great because it means things are trending in the right direction, and hopefully we see those trends continue as more people are able to get vaccinated and other things, so we go in the right direction. So I think that at that point, it puts us back to the IDPH's sports safety guidance. And so I think that so long as we're complying with IDPH's guidance on sports, we can move forward to the extent based on what tier we're in and based on the various sports, what level of risk they are at. And so I think that that's again one more step towards normalcy. I think that the important thing for me is careful adherence to the IDPH rules. I am secondarily interested in anything IHSA or similar groups have in their guidance. As long as IDPH is being followed, I think that's the key for me. And I think that answer right now is going to be slightly different based on which tier you're in. And I know many of us here participating today are in different tiers of phase 4 right now that would allow us to have different activities be available, and all the complicated factors with that. But that's one more step towards normalcy, and make sure we're carefully following the IDPH piece. I would encourage people not to just focus on IHSA's all sports guidance, but make sure you're looking at IDPH's tiered guidance for various athletic events.
And one thing that I'd caution too at this moment, you'll recall on several of these calls and several of these videos we've talked about not being the first out of the herd, not being the last behind the herd. Know what's going on in your region, know what your neighbors are doing. I recognize you're getting a lot of pressure from coaches, from parents, from community. You need to get back to sports. I get that. I feel the pressure myself. I understand it. But remember that if you're the first one out of the gate, the people who are loud are the ones who are not at the moment getting what they want. And that shifts the moment you change what you're doing. There's going to be somebody else who's loud. There's going to be somebody screaming, you shouldn't be doing sports. You're putting the kids at risk. You're putting community at risk. It's just going to shift on you. Take your time for the moment. Go slow, because in some regions, there's going to be great pressure to play. There's going to be great pressure to get going. And that pressure will build on everyone else at the same time it's building on you. So when everybody goes, it's going to be a lot easier on you to go. Similarly, there's going to be pressure in some places to do less, and you don't want to be the first guy out of the gate to get clobbered. Do yourselves a favor. Remember that sports aren't mandatory this year, at least not yet. So your choice to do so is an acceptance of some degree of risk. And there are countervailing risks all over the place that we're dealing with. There's risk to not having sports. There's risk to having sports. Be careful before you get going that you know what your neighbors are doing, that you know what your local Department of Public Health is doing, and be aware that the last time we were permitted to do some sports, Brandon, I don't know about you, but I had a whole bunch of districts that were struggling with coaches that disregarded the guidance entirely and did what they wanted to do. And those are liability driving situations. I had a number early on that shut down entire schools because of outbreaks on a team. So please be careful and make sure you're doing what the guidance requires you to do.
Yeah, I think when we start to do too much too fast is what's going to cause issues for us, because the last thing we want is by starting sports that we have to close school because too many people are now in quarantine for those reasons. And that's why the careful considerations and carefully following the IDPH rules when it comes to those activities and their suggestions is key. And it just takes one rogue coach to not be following the rules to create liability concerns for the district. So that's what's really important for me. We've got one other question on an unrelated topic before we close out here. We got about a minute or so left before 3 o'clock, but let's ask it. And this deals with that. an administrator contract is a max of 5 years. The school code says that you can have an administrator contract for up to 5 years. Well, if you give a 5-year contract to somebody who still has a year or two left on their contract, is that exceeding the 5-year maximum of the contract to have somebody under contract for more than 5 years?
Arguably, yes. I mean, I'd be okay, two things. First, this does happen. I want to be clear. If you go check your neighbors, you may discover somebody's got a 5-year contract that was just acted upon that starts. But I'd be concerned if I were not the board, from the board's perspective. I mean, the worst that happens from the board's perspective is a new board wants rid of the superintendent on a 5-year contract and has a viable argument that that contract is invalid. It's void ab initio, voided at the time that it was entered into because it's a 6-year contract. It effectively protects them more than 5 years out. So from the board's perspective, I don't have a ton of risk. But from the employee's perspective, I'd be very nervous about that, because the employee is at least without a contract potentially for a few months while they're waiting for that new term to start. And potentially, if we've got an election in the middle there, which we do, and the board turns over, there's a pretty significant amount of risk. There also remains risk during that 5-year period that if the board sours on you, they might take off that argument. If it were me, I'd want to make sure that the total amount of time doesn't exceed 5 years. Of course, you can enter into a 5-year agreement at some point in the spring when you're right on top of that. But the more you can, because obviously you've gotten through the year, it stands to reason that they can do, if they can do a 5-year contract, they've got to be able to do that before the contract starts, for the first day of the contract. May, June, no question in my mind, you can do that. But if we're doing it here in January, you're accepting some risk, and so you have to ask yourself how much risk you're taking.
I agree. I've generally said that the total period that you have contracts with doesn't exceed 5 years. And I would say when you're in that last year and you get after April 1, it's too late at that point. You're in for the rest of that year. And so entering into that 5-year contract that begins July 1 is probably safe at that point. But earlier than that, there's risk, and the risk is more on the administrator than it is on the board.
Yep.
Well, thanks, everybody. We had great turnout today. Great questions throughout today. So glad we could do this again for everybody, and glad that you could spend some time with us. So like I said, I'll send the PowerPoint and a follow-up email to all the participants so that you have a PDF of the PowerPoint that we used today. So thanks again for participating. Our intent, also a question here, is to post this on our YouTube like we have been for our Q&A sessions. So in the near future, hopefully maybe later today at the earliest, we will be able to get this up on YouTube if you want to listen again or share it with others.
And on our YouTube channel, there's a button there, a little bell there, and you can get notified anytime we post something. And sometimes we don't necessarily host them the same way we have here. So we post things with some regularity, and certainly more as time goes on. So if you hit that bell, you'll know every time we post something new.
So
thank you all for joining us. We appreciate it.
Hang in there, everybody. We'll talk to you all soon.